Welcome back to the second part of day one of the Florida Part A crash course with Ibis Prep. It's your boy, Andrew, professor, and we're gonna do what's gonna be the most valuable thing that we do, I think, in these courses, which is go through model essays and go through our outlines and just get comfortable with how we're gonna write these essays. I think a lot of my competitors just lecture and teach the substantive law, which is very important, but they don't do enough of preparing people to execute on test day. So I really built my program around that philosophy. Make sure I don't have any tabs up like that one professor at UM. So here I have a folder that you guys should all have access to called Essays and Model Outlines. You can access the contracts one, and you see we've compiled all of the essays for you right here with the essay and then the model answer as written. And then on top of that, if you go back to contracts folder, if you go back to Florida essay subjects and actually go to the contracts folder itself, we have model outlines that we created for a lot of these. I'm gonna start off kind of looking through these first, just to give you, what's on here, and then we'll get rocking on some different ones. You'll see the repetition is glorious. All right, this was an essay from 2013 that was half contracts, half Article 9, my favorite subject. But for now, we'll just focus on the contracts piece. To be enforceable, the contract must have an offer, an acceptance, consideration, and no valid defenses. An acceptance is a manifestation of intent to contract under the terms of the offer. In Florida, consideration to support a contract must be a legal benefit to one party or a legal detriment to the other. Under common law in the UCC, valid consideration consists of a bargain for exchange. Under the Statute of Frauds, certain contracts must be in writing: marriage, land, sureties, executorships, such as surety agreements, service contracts exceeding 1 year, sale of goods exceeding $500. This dude definitely had the acronym jumbled up in his head. Under the Statute of Frauds, the present construction contract does likely not need to be in writing, as it can be performed in 1 year. See, I highlighted that as an example of look out for the 1 year stipulation. In addition, courts will generally not preclude proper modification of a contract based on a writing only clause, where the parties manifest the intent to subsequently change the contract and the modification is properly effected. It's kind of a dialed in rule. We'll kind of see about that. Statute of Frauds and writing only clause would not bar modification of the parties' contract. Parole evidence is only prohibited to contradict or supplement an integrated contract with prior writings or prior and contemporaneous oral agreements. Evidence of condition precedent. Remember, these are exceptions to parole evidence. Evidence of condition precedent, mistakes, or of subsequent modifications may be considered where necessary. Under the common law, contract modifications must be supported by separate consideration, right? But if they're merchants, boom, 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 without consideration. A pre-existing duty to perform is not adequate consideration to support a contract modification, right? If you're already obligated to do something, that's not going to be adequate consideration. Under the UCC, when they're merchants, no additional consideration is necessary for a good faith modification. Generally, a contractor must complete his project without additional compensation if the partially completed structure is destroyed through no fault of either party. The defense of impossibility is considered an objective basis, or whether a party can reasonably perform. To allege impracticality, he would have to show that an unforeseen event, the non-occurrence of which was a presumption of the parties materially altered his performance to such an extent that the performance is excused. See, this is a good definition of impracticality. Remember, these definitions that we took out are people writing on the fly. These are real students' definitions. We just teased out the rules for you. Provisions regarding insurance of the failure party to obtain insurance will likely not render a contract unenforceable. Generally, a unilateral error by one party does not stand as a hindrance to contract formation. This is good language of what I've been saying. However, where the other party knows or should have known of the error, he will not be allowed to snap up the benefit of the mistaken agreement. That's cute. Where the parties did not enter into a binding contract, an aggrieved party may obtain relief based on promissory estoppel or detrimental reliance. To prevail on detrimental reliance, the injured party must show a promise from the breaking party that was intended to create reliance, justifiable reliance on that promise, and that injustice would occur if the injured party is not awarded damages. That's a good definition of to prevail in detrimental reliance. Compensatory damages are awarded to a non-breaching party to put them in a position they would have been absent of breach. Compensatory and expectation damages include incidental and consequential, liquidated when appropriate. Punitive damages not usually awarded in contracts. When a non-breaching party reasonably covers as his duty, he'll be entitled to the difference between the contract price and the cover price plus any incidental consequential damages. Okay, do you see that was all the contracts checkpoints? That's where they got all the rules of. And we talked about all those things. Nothing in there really was like new to me. So happy with that. All right, let's look at another one. You see, I'm very thorough with this. We're going to go leave no stone unturned. 2016, pure contracts essay. What did they talk about? Formation. A contract is an agreement or set of promises that are enforceable by law. For there to be a valid contract, there must be mutual assent, which is a valid offer and acceptance of clear terms that both parties intend to be bound by, supported by consideration, no valid defenses. You see buzzwords, buzzwords, buzzwords. Offer may be accepted by the manner indicating the offer by any reasonable manner. Performance is by implication, conduct, or acceptance. Under the common law, we have the mirror image. Acceptance must match the offer exactly. Any changes are deemed a rejection and counteroffer. Under the UCC, amended terms are only accepted if they are merchants and do not materially change the offer, or the offer was not expressly conditional to acceptance and the offer does not object within 10 days. 10 days is usual if you're going to reject to an amended term of a merchant's UCC. Considerations of bargain for exchange, legal value or detriment in Florida, UCC, sale of goods, which are tangible and movable property, statute of frauds, sale of goods over $500, predominant purpose. This is a good sense right here. When a contract is mixed goods and services, the law applicable to greater in value will apply, the predominant purpose test. Statute of frauds, 1 year. A writing can be more than one document as long as it's clear as referring to the essential terms of the agreement, and the signature can be any method that indicates the party sought to be bound, such as a company letter or letterhead, seal or letterhead. Right, a signature in 2022 could be anything. It could be a drop of blood. All right, so then they go into mutual mistake. When there's mutual ambiguity or mutual mistake that goes to essential element of the agreement, both parties were unaware of the ambiguity mistake, the agreement may be rescinded and each party shall be entitled to claim in restitution anything that have greater value. That's cool. If it's a mutual mistake, rescind the contract, and in restitution, any value you put in, you get back. If one party is aware of the ambiguity or mistake and the other party is not, the contract may be enforced in favor of the party that is not aware of the ambiguity, right? That's the good faith thing. Like, if you were doing this on purpose, you sneak, we're going to get you. I told you non-competes were going to come up. It's like I've done this before. Contracts that limit a party's ability to compete are valid as long as signed by both parties and reasonable as to the geographic scope, subject matter, and time limits. Limitations on patents are, I told you I was wrong about this. Patents are 5 years or less. I'm pretty good at, I'm very honest. If I don't memorize something perfect, I'm not going to lie to you. So patents, 5 years or less. Limitations on patents are deemed reasonable if the limit is 5 years or less. Rebuttable presumption. An employee may be required to give ownership of intellectual property to employer during employment if developed for employer during scope of employment. Now, I want to mention something here. How many people who took the bar exam in 2016 knew that limitations on patents were deemed reasonable if the limit is 5 years or less? I would say 3% maximum, right? You don't have to know everything. This is the model answer. But I want everyone to strive for greatness and try to remember even the little tiny things so that you can try to write a model answer. But don't be intimidated when you're like, how in the world did they know that? You know how they probably knew that? They probably interned at a patent law attorney. You know what I'm saying? Like, don't be overwhelmed by the greatness of the model answer. Okay. Parole evidence we talked about. Non-competes, parole evidence. Evidence of oral agreements prior or contemporaneous with the agreement are usually not permitted if the agreement is fully integrated, full expression agreement. However, it's allowed if there's ambiguity, not fully integrated, supplement the agreement as long as it does not materially contradict the terms of the agreement. Plaintiff can bring in extrinsic evidence to clarify the scope of the patent obligation and what was meant for cause. So non-competes, parole evidence, accord and satisfaction. When there's a dispute as to a debt, a party that offers a lower amount in satisfaction of debt and rights paid in full fully performs and is discharged. Hey, that was what someone said about they learned beginning of class today. See, true statements. I probably just added this to help y'all. Delegation duties, assignment is the rights, novation is substituting another part of the contract. Okay, cool. Let's see what else we got here. February 2020, again, employment contracts, but this is a little bit more particular. It talks about at-will contracts. Generally, employment is considered at will unless there's an enforcement employment contract. A contract is an agreement formed following offer acceptance consideration, statute of frauds. A court will not award specific performance for services, right? You can't be ordered to do a service. That's because it would be involuntary servitude. You see that a lot of the things I say, and people probably like, oh, wow, you're smart. You know this stuff, is just because I've memorized it off of some outline. That's what I want you all to recognize. Like, let's just obsess over these outlines so that we sound smart. Okay. Involuntary servitude. You can't have a specific performance. I can't force someone to do something. I can force you to give me the piece of art or the land. I can't force you to mop my floor. Even when the services are unique, blah, blah, blah. Right, involuntary servitude. Damages, compensatory damages, expectation, non-breaching party where they would have been if fully performed, consequential, that were reasonably foreseeable, should have known were foreseeable. We talked about that. Non-competes, look, coming up again. Non-competes, limited degree, legitimate business interests, no more restrictive than necessary, sufficiently limited in scope and duration. Absent a showing of unique circumstances, courts will not enforce non-competes for more than 2 years. Okay, so 2 years. There's a presumption that non-competes for less than 6 months are reasonable. I knew I was right about something. And that non-competes of more than 3 years are not enforceable, right? So like, these are presumptions. It's case-by-case basis. It depends. What are you being told not to compete for? Does anyone out there have any questions about non-compete and what that means? I'm sure you've all signed them in your lives. My tutor signed a crazy non-compete agreement. They probably don't even read the contract, but I've never enforced it. All right.
That's hilarious.
My contracts are insane. Because like I have, a bunch of attorneys that work with me. So we make sure that, I don't know. I don't want to talk about my business. Let's talk about your guys' test. B, intentional interference with business. Oh yeah, I know about this one. A claim for this tort requires an existing contract. The defendant knew or had sufficient knowledge to know with reasonable certainty that contract existed, and intentional interference with the contract that caused the other party to breach. That sounds what it is, right? Intent is always going to be the key thing. Intentional interference, intentional infliction of emotional stress when we do torts. This is just an intentional interference claim. Oh shit, we're going on to torts anyway. So that is a tort. So contracts, employment contracts, at will, unless there's an enforcement, no specific performance for services, damages we've already talked about, and then we went into non-competes. This is all torts. We don't even need to go into that. To me, it all kind of bleeds together. I think this must have been done by a student because it seems, oh no, this was done by me. So yeah, these are some outlines that I did myself when I was studying for a different state exam. But contracts is contracts all over the country. Anything that was particular to the state I was doing, I took out. But this is just more things that, contract formation, UCC, offer acceptance, consideration, boom, boom, boom. Advertisement is generally not considered an offer unless it specifies essential terms and provides an offer with a method of acceptance. Talked about the statute of frauds, talks about land. Part performance in a land conveyance requires that the party who seeks to enforce the contract must have engaged in partial performance, which is usually evidenced by possession or payment of the purchase price. Equitable estoppel requires that the party who seeks to enforce the contract shows that there was a promise and that the party reasonably relied upon that promise. So we talk about that promissory estoppel, equitable estoppel, same thing, that reasonably relied. Breach. A breach occurs when one party fails to perform as obligated under the express and implied conditions of the contract. Anticipatory repudiation occurs when one party demonstrates unequivocally, we want to use that word, that it will not perform under the contract. In this situation, the non-repudiating party may request assurances, and if it reasonably certain that the contract has been repudiated, may sue for breach of contract or suspend performance and wait for the actual breach to occur. See, this is getting very repetitive. We're going to make this whole test repetitive, and that's what's going to make us pass. We don't want to get surprised by anything. We just want to be like, oh, another contract essay. So damages, expectation, duty to mitigate, right? You do have a duty to mitigate. You don't have to settle for lesser employment or move to a distant location. Restitution, when one party has a benefit bestowed and it would unjustly enrich the other party if they're not required to pay for the benefit. Remember, Grace, you were saying use your own language. These are great places to get your own language because they're not anyone's language except for model students. That's how we created these outlines. Your own language should be model answer language. That's the best language. Don't reinvent the wheel here. So these are a great place to restitution damages are only awarded when a benefit has been bestowed and it would unjustly enrich the other party if they are not required to pay for that benefit. That's a beautiful definition of restitution. Is it the only definition that you're allowed to use on the test? No. That's why I say your own language. Just find something that's solid and just over and over and over again. All right, specific performance, inadequate remedy at law, feasible, mutuality. I'm not sure exactly what they mean by that right there. Mutuality. Definite and certain contract and inadequate. I guess mutuality meaning like the contract, there's a mutual understanding that was going to be the piece. The party attempting to avoid specific performance can do so by raising various defenses. Oh, here's a new one. I knew there were some new ones that we could talk about. I like getting deep in the trenches of subjects. I'm obsessed with finding little things that we can get points on. Latches or unclean hands. Does anyone know what they mean? Latches or unclean hands?
Latches is like basically like there's a delay that is like not unjustified, and so I can't like if I ordered widgets from you and they're supposed to be delivered by this date and there's a massive lapse in when they're delivered and I now can't sell them, then I don't want them anymore.
Right. Latches is an unreasonable delay, and then unclean hands.
Unclean hands, I think, is more that just that someone was unfair and therefore the other party requires relief. I don't know.
Yeah, I have it. It's just that you participated. Latches, the defense applies where a claimant unreasonably delays in bringing suit and where the suit prejudices the plaintiff. Unclean hands, an equitable offense available where the plaintiff has engaged in some wrongful or inequitable conduct with respect to the same underlying transaction for which the plaintiff is seeking relief. Like, you're guilty too, unclean hands. Now, what you see what I have here, what I've done for y'all is very helpful because I took California bar exam. I'm actually going to take Pennsylvania and Maine. I have a plan in place. But one thing that's different about California and Florida is that in California, remedies is its own separate section from contracts. They literally can test you just on remedies. So me understanding that Florida combines them and that California gives us all these model answers for remedies, I was like, oh, these are really helpful documents. So I created these two remedies documents that really can help you all understand remedies a little bit better. What's necessary for a TRO, for a preliminary injunction, these equitable defenses of unclean hand latches, and exactly what's required for specific performance. So anything else we see here? Reformation, parole evidence, estoppel, unclean hands, the mistakes, fraud, misrepresentation, rescission. I really want everyone to spend as much time as possible this week dedicated to the memorization aspect and recognizing that you're not taking this test for like 10 weeks, but you got to memorize a lot of stuff in the meantime. So it's got to be memorized and understood. It's one thing to just memorize the words. It's another to understand it. And I always tell people this is why I got into teaching. Like, if you can explain it to someone else so that they understand it, then you finally understand it. That's your true test of like, can I take my nephew or my friend or some idiot on the street and explain to them what latches is? You know what I mean? And if they're like still looking at me like dumb, then I'm like, I don't really understand it. I've got to be able to break it down and answer their questions. Like, latches, what does that mean? Oh, like, someone's trying to sue for a breach of contract, but they just took too long in bringing the suit. Oh, so it's kind of like statute of limitations. Yeah, it's kind of like statute of limitations. You know what I'm saying? Like, that's like a fair street conversation of having. We want to have these street conversations with all of these things and make sure we understand them. All right, the last one we'll look at before we look at some real essays, Ucc Common Law Offer Acceptance Consideration. Here's a good one. I'm trying to tease out as many little points as we can get. The only essential terms under the UCC are party, subject matter, and quantity. Remember, price is not an essential term. Price can be ascertained by the court under the factors of reasonableness. I have such ADD. I just was thinking like about lunch, and then I remember that's graduation weekend, and the Grove is like super packed right now with graduates. But back to this. Formation, offer acceptance consideration, party, subject matter, and quantity. So goods, all things movable, tangible objects, boom, 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 merchants, special rules for merchants. And merchants is, here's a good definition: someone who regularly deals with the type of goods that are the subject matter of the contract, someone who has special knowledge of such subject matter, or person involved in the transaction. Anticipatory repudiation, we talked about what you may do. You can either treat it as breach, so immediately, treat it as rescinded, suspend performance, and then wait and sue. Times of the essence clauses, not typically enforced as a material breach unless this has been specified when the contract was formed. So times of the essence, those are contracts. Those are construction clauses. And they're saying it's not going to be material breach unless it's like a liquidated damages clause. You see that like the plaster needs to be put in the state or it'll affect the whole project. So that's interesting. Perfect tender, we can understand it's got to be UCC, you got to deliver what's delivered. Contract modifications, modification under common law, consideration, UCC, good faith, no consideration necessary. Adequate assurances, remember I said typically not 30 days. This goes within anticipatory repudiation. You can revoke the repudiation, right? If they haven't rescinded, they haven't materially changed their position in reliance to repudiation, and the other party has not filed suit. Impracticality, unforeseen occurrence, impossibility, if it's not objectively possible. Compensatory damages, you know, we talked about expectation damages, consequential damages, foreseeable, incidental damages, trying to remedy the breach, reliance damages, you know, that's kind of like the, they actually relied on it and it would be unjust not to pay them. And then duty to mitigate. A non-breaching party must do all that's reasonably possible to mitigate damage and eliminate cost. The damage is recoverable, reduced by what has actually been mitigated or what could have should the non-breaching party fail to take steps, right? We saw that answer. A few of us were on the fence there about, oh, do you get the $1,000 back even though you didn't hire the other tutor for $5,000 compared to $6,000? And the answer is yes. What could have been mitigated if you didn't fail to take those steps. So those are some good outlines. You know, I really pride myself on the work we've done over the years to like spoon feed everyone helpful stuff. So I want you to really spend time going over those outlines, etc. What I really want to do now is look over some of the actual essays. Let me see. Let me pick a good year. Good year. Oh yeah, 2008. That's the year I graduated high school. Good year. My first year of college. The Phillies won the World Series. I like that team. All right. So let's kind of look at this question and see if we can do this. Does anyone want to read the first paragraph and see if we can identify some issues? We're gonna issue spot this.
I'll read it. Oh, go ahead.
Okay.
Worried about
okay. Worried about the wildly fluctuating price of oil, airline wrote to oil company requesting a firm price. A firm price on jet fuel for 1 year. On September 15, 2006, oil company wrote to airline stating, I offer to supply you with any jet fuel ordered by you during the upcoming year beginning January 1st, 2007. Price $1.50 per gallon to be ordered by you in minimum quantities of 50,000 barrels. Because of your past business, this offer will not be withdrawn during the year. Airline received the letter on December 20, 2006.
Okay. They could not have made it more clear that there is what issue being presented. What topic are we talking about here? What type of offer?
option contract?
Yeah, an option contract.
Right, a firm offer. They literally use the word, a firm price. And then they even like doubled back on it. Like, and because this offer will be not withdrawn during the year. Like, this is definitely an option contract. They have a firm offer, right? So off the bat, what, you know, and like I said, I gave you all those outlines. I mean, there's always some new stuff. What about firm offers do we remember?
That they'll stay open for a reasonable time, not to exceed 90 days.
Exactly. We have that right here. We also have merchants, don't we? Airline and oil company.
Right. Sorry. Yeah. That it's also it's a contract between merchants.
Contract between merchants, firm offer, and that's gonna, assume 3 months that the offer is gonna remain open. Okay. Price $1.50 per gallon. Minimum quantities of $50,000 barrels. Nothing too much right here. We definitely know we're in contract law. Why don't, Joel, you read the second paragraph and see what we got here? What issues?
Sure. On December 24th, 2006, airline replied in writing, "I accept your offer. Mail was delayed during the holidays and oil company did not receive this communication until December 31, 2006. Because the price of oil was rising so rapidly, airline called oil company on December 26, 2006 and orally stated to oil company's agent, I accept your offer of December 15th. In the same telephone conversation, airline requested the immediate shipment of the 100,000 barrels. Oil company's agent orally agreed to ship the 100,000 barrels that day, but informed airline that the price for the rush order would be $1.70 per gallon. Oil company delivered the fuel that day based on the $1.50 price for the 2007 from oil company. Airline canceled all other negotiations with suppliers.
Okay, excellent. Now, I recommend approaching essays like this. First, I would have read the call to question first just to make sure we know what world we're in. Claims of airline and oil company as well as any defenses. So like literally, I'm thinking 2 headers. Claims of airline, claims of oil company, defenses. Like 2 columns, claims and defenses. We're trying to just identify all that. And then it says, do not discuss any issues related to damages. Be mindful of that. All that damages talk we did, we're not going to need to talk about. We just need to talk about claims. But remember, this is a bar exam test. Any legal issue needs to be brought up. If they say a weird word, that's a legal word, that's legalese, we want to define it. So here, first paragraph, we identified some issues. Issue being firm offer, issue being merchants. They were pretty clear about it, like literally firm price, remain open. What did they really clearly make clear are issues in this second paragraph?
First thing that I guess stands out to me is the acceptance. So they're talking about the mailbox rule right here.
Boom. So we got to rewind that. Acceptance. Okay, now we have a contract. This was a firm contract. So we're already going to start with getting all of our points for, is this a contract? What is a contract? Offer, acceptance, consideration, all those things are going to tease out. We have that. I accept your offer. Now, they said the word mail. That teed off to you properly, the mailbox rule. Okay, cool. Now, I would just like, if I'm doing this test, I got to remind myself. What is the mailbox rule? Joel?
That a acceptance is officialized. I'm losing the word for it right now, but acceptance is valid upon the dispatch of the acceptance.
Right.
So I should put in the mail.
Receipt and acceptance is effective upon dispatch.
Right.
Okay. So what else? We have mailbox rule. Mail was delayed during the holidays and oil company did not receive communication to this because the price was rising so rapidly. They called oil and orally stated. What does that word orally suggest we need to talk about?
Modification.
Go ahead. What'd you say?
A modification.
Modification, merchants, right? We identified their merchants. What's the rule about merchant modification?
That they don't need consideration, a new consideration.
And it could be oral, right? Oral is okay. They don't need new consideration. But what was the statement? I accept your offer of December 15th. Saying, what does that mean? I accept, in the same type of conversation, you requested the immediate shipment of $10,000 barrels. What does that refer back to? I accept your offer of December 15th.
What?
This statement right here.
I think that's
The
just
very top, I think.
That's this.
Mhm.
the same offer, I believe.
He's just like saying again, he's reaffirming.
Right.
He's not reaffirming. He's just reaffirming this. Okay. In the same telephone conversation, and he could. Acceptance can be by any method. It doesn't need to be by mail. It could also be oral. So he's just accepting it twice, basically. Now he requested the immediate shipment of $100,000 barrels. They orally agreed to ship it that day. So this is a separate contract, right? You gotta tease this out. Now, is this contract, what does it fall under, UCC or common law?
Well, that's UCC, right?
UCC.
UCC. And is there anything special about it because of the price of it?
Statute of Frauds.
Are you referring to like the goods rule?
Yeah, I think both of them are going to implicate the statute of frauds, right?
Correct.
Both of these are going to implicate because it's goods over $500. This one I'm doing the math on right here. I didn't even necessarily catch that at first, but this one's going to implicate the statute of frauds. So this oral acceptance probably doesn't suffice, but this written acceptance should suffice, right? Now, this one probably is not going to conform with the statute of frauds because it was oral and it needs to be in writing based on the dollar amount, right? Now, why did they say, okay, but then delivered the fuel that day? What does that implicate or make us think of?
Well,
Performance, right? So even though it should have been under the statute of frauds, we're going to argue performance is going to overcome that defense. Good. We're catching on to the right things here. What about cancel? Why? Like, I have this way of thinking. I don't know. I consider myself a writer. Writers write words for reasons and sentences. So I always try to ask myself, why did they write this sentence? What point can I get off of this sentence? I have a good one right here. Airline canceled all other negotiations with suppliers based on this conversation. Why would they write that sentence? What issue could they be bringing up for us to get points on?
like reliance.
Yeah, reliance. That's what I'm thinking about. Some sort of reliance that you actually. So we're writing out all these issues that we're spotting. Offer acceptance consideration, valid defense being the statute of frauds, as it applies both times. Mailbox rule, writing out what the mailbox rule is. Reliance, talking about that as an issue. Modification, talking about that. Good faith. These are points. We can get a lot of points just by teasing out everything. But make sure you take your time to do the offer acceptance consideration, no valid defenses, UCC versus common law, mirror image rule, like all that jazz at the top. The perfect tender, meeting of the minds, mutual assent, get all those points, squeeze every drop out of those lemons. So when you get stuck, which you will, because these questions are hard, right? They're not easy questions. At some point, you're gonna be like, I have no idea what to write. You'll be like, good thing I got a lot of points at the beginning. That's kind of how I teach. All right, so we've identified a lot of issues. Any other issues anyone sees in these first two paragraphs? The performance thing, I'm glad we talked about that. Rush order, change of the price.
What about what it says in the first paragraph that the offer will not be withdrawn during a year? Is that important?
That's going to be with the firm offer and it has to remain open, and it's usually not to exceed 2 years, but they have an express condition of 1 year. So it should last 1 year because as an express condition. All
We
right.
discussed because the price of oil was rising so rapidly.
What would you say about that? What issue would that might implicate?
I mean, that might be a defense of, I know sometimes if things change, then they can try to change the contract because prices have went up, if it was reasonable or not.
What you're identifying is something that I think people don't do enough. Sometimes you'll see something, you'll think about it for a second, and then you'll overcome it in your mind and then not write about it. I encourage you to actually write about it. You're probably thinking the natural thought process for a law graduate here is, oh, rising prices, oh, but that's foreseeable. But you should write that. Be like, X may argue that, because the prices rose rapidly that they can, rescind the contract. However, rising prices are foreseeable and therefore they would, be required to incur that risk of loss. Right? So like get used to fleshing out even like assumptions just to write and to get points. Okay, we're doing a good job so far. Who wants to read the third most juiciest paragraph?
Read it. During January and February 2007, airline ordered 200,000 barrels of fuel. The fuel was delivered and airline paid for it at the rate of $1.50 per gallon. Airline also paid for the 100,000 barrels shipped in December 2006 at $1.50 per gallon. During the first week of March 2007, severe weather destroyed a key pipeline in a major oil producing region, resulting in the disruption of the world supply of oil and causing the market price of jet fuel to rise to $2 per gallon. On March 7th, 2007, oil company mailed a letter to airline reading, "The offer dated December 15, 2006 is revoked." The letter did not arrive until March 16, 2007. Airline placed the following orders, all by mail: 50,000 barrels on March 10th, 50,000 barrels on March 17th, and 100,000 barrels on March 30th of 2007. Oil company received all orders 2 days after mailing, but refused to fill any of the March 2007 orders.
Okay, let's do some issue spotting.
Okay.
No, go ahead, Ben.
I was just going to say that the revocation wouldn't have been effective until it was received. And the revocation was received March 16th. And they placed an order March 10th, I see.
So you're talking about the mailbox rule. That's a third prong. Offers are effective upon when they're received, acceptances when they're sent, and then what about revocations?
Revocations are receipt also.
When they're received, exactly. So that's another point about the mailbox rule. And I'm always keen on the mailbox rule because Kim Kardashian flunked that part of her test.
Right.
What else do we see here in this?
They paid $1.50 a gallon per gallon, which
impossibility too.
Yeah, I was gonna say frustration of purpose.
yeah.
Definitely frustration of purpose here.
Yeah.
Okay. What else? What's the key word that is going to come up in every contract essay and we need to talk about here? Claims. What are the claims you're going to have? What's the always claim you have in a contract?
Breach of contract.
Breach.
Contract. So where are the breaches here? What are we going to argue for? Try and put them in order. Who's going to claim what happened?
I'm sorry, can you repeat the question?
Who breached the contract here?
The oil company?
When? Right? When they're
Right.
refusing to fill the orders. That's going to be the main thing here, right? They refused to fill the orders. We had a contract to fill the orders and they didn't fill them. We're going to argue that's a breach of contract. Definitely a material breach, right? but they would have these certain defenses available. Okay. Anything else we see here? We have the severe weather destroyed a pipeline. It's revoked, but we say it's not gonna be effective until received. We're gonna talk a lot about the mailbox rule. They placed these orders. They received all orders 2 days after mailing, but refused to fill any of the March 2007 orders. That's what we're gonna argue is the breach, right?
Isn't the
Go ahead.
I'm just the line that says the offer dated December 15th is revoked.
Mm-hmm.
Is there an issue in there?
Yeah, what do you reckon is the issue?
Well, the offer was already accepted, so don't you have to revoke before acceptance?
Exactly. It's too late. We kind of established that revocation is going to be ineffective. They also paid for the barrel shipped here, severe weather. So we'll talk about, what would we say about the frustration of purpose? It rises to $2 per gallon. There's arguments on both sides, right? Whether that was foreseeable, whether that risk was to be incurred by either party. So let's see how the question asks. Senior partner requests that you prepare a memorandum discussing the laws, the claims and defenses, no issues related to damages. So we're gonna get most of our points talking about what is a contract, have proper contracts been formed, talking about the issues of the modifications and the performance and the fact that they're both merchants, talking about the firm offer rule and that they couldn't rescind it and what's necessary for a firm offer. Definitely talking about all the different pieces of the mailbox rule, talking about frustration of purpose. This isn't the juiciest essay. I find this to be a hard one. You know why? Usually a Florida essay, and like I told you, I took California. California essays are super short and concise. There's like 3 issues, you write about them and move on. Florida essays are usually there's like 20 issues and you don't have enough time to write about all 20. This, and I kind of like that because you can keep hopping around and writing. This one is a tough essay because it's like not too much, right? It's just a couple contracts, couple issues here and there. Let's look at how the model answer really went through this and got their points. Oh, what do you know? They started with a valid contract, right? They did it. I don't know. Let's see. A valid contract requires offer, acceptance, consideration, no valid offenses. Every one of my classes is getting that point on the test. If not, leave now. The law governing contracts depends on subject matter of the contract. UCC, sale of goods, Florida common law, sale of services. We're all getting that. The subject matter here is jet fuel. Jet fuel is a good, therefore UCC, boom, boom, boom. We're getting all that. They haven't said anything miraculous yet. An offer is a manifestation of intent to enter a contract or words of conduct that gives the offer the power to accept. To be valid, the offer must have the language of commitment and definiteness. We're all getting this point. Check, check, check. Acceptance is the manifestation of intent to be bound by the terms of the offer. Consideration, bargain for exchange, Florida files a that consideration is there, benefit of the detriment, both. Under the UCC, a valid contract does not have to state all material terms, rather contract. Do you see how they write like I'm telling you? You literally, like, I'm not lying. You have to write like this to get all these points. But if you paid any attention to me today, we've like got these points down, down, down. We're getting all these points. We haven't even gotten to the question yet, right? We're just literally just dumping our outline. But make sure you do that properly. All right. It was not an offer, but a request for information. Request for information is not a valid offer because it does not contain commitment and definiteness. This reply is a valid offer because it contains language of commitment was definite. The offer was firm in that it promised not to withdraw the offer during the year. Under the UCC, the offer is valid without consideration. Firm offers are valid for 99 days unless it states otherwise, which we said stated for a year. Under the UCC, firm offers cannot be revoked for 99 days and arguable anytime longer than 9 days if the parties shall intend. In this instance, like, I don't really know what he was talking about, the request for information piece. I'm not worried about that. I'm worried about, like, are we getting all the main points right here? Now, my curious brain is going to, look into requests for information, but I'm not going to be like, oh my God, I failed this essay because I didn't mention that. I'm going to be like, crushed it. Paragraph 1, 2, 3, 4, I got it. All right, paragraph 5, we talked all about this, that it's a firm offer, 90 days, unless they specified a year. We're all good there. Boom, hold it open for a year. They accepted by communicating a manifestation of intent to be bound by the terms when they called and verbally accepted. Talked about that. Mailbox rule. We talked about this. It does not apply under the UCC. Interesting. The mailbox rule does not apply under the UCC. They just wrote that randomly. The mailbox rule states that an offer is accepted upon dispatch, meaning upon placing the acceptance in the mail. However, since it's a contract for sale of goods, the mailbox rule does not apply. Therefore, the offer was accepted when airline telephoned oil indicating his or her intent to be bound by the terms. Okay. I was not 100% aware of that. Is everyone out there in agreement with that? Or do I need to look that up to verify that?
I don't think I was aware.
These are model answers. These aren't always correct. We got to remember that. These are just people's thoughts. Can we verify this?
To be clear, this is Florida's model answer, though?
Yeah, this is the Florida model answer from February 2008. But remember, they say specifically, they do not edit the answers. Some things are bullshit. So I've been teaching for 5 years. I don't know that to be true, but let's verify that. The mailbox rule does not apply under the UCC. We can verify that easily. Does the mailbox rule apply under UCC?
I'm seeing that it does.
Yeah, it definitely does. Exactly. So, the mailbox rule is out of common law. It's kind of interesting. It's a common law rule. Are you seeing that it applies to UCC?
I saw the same thing you got as your first result. Pretty much it's saying that by dispatch.
What I see down here, the majority rule is that the mailbox rule does not apply to option contracts. It's a default rule. This is interesting.
I didn't know that.
Oh, I think that sounds a little familiar from contracts. Let me see.
Again, remember, this is the model answer. 99% of people are just you still got to talk about the mailbox rule. Whether it applies here or not seems to be ambiguous to me, but we're learning a little bit. The mailbox rule, and I love learning, I really do love it. The mailbox rule is born out of common law. Whether it applies to goods or not is actually a majority versus minority decision. And I see right here in the United States, the majority rule is that the mailbox rule does not apply to option contracts. By default, an option contract is accepted when the offerer receives the acceptance and not when the offeree mails it. However, because California code applies the mailbox rules to all contracts, California follows the minority rule under which the mailbox rule applies to option contract. What about Florida? That's a great thing. Like, that's why I do these small group courses. I want to dig into the real trenches of this stuff. Does the mailbox rule apply here? Remember, you're not going to get a bad grade if you write about the mailbox rule here, because he did too. So we're on the same terms here. Okay.
I'm also seeing that, sorry to cut you off. I'm also seeing that I pulled up one of my contracts focus outline from this last semester. And I'm seeing the same thing here. Acceptance under an option contract which is effective upon receipt by the offer.
All right. So let's go with the majority rule. The majority rule is that options contracts under the UCC will not follow the mailbox rule. Now, do you still talk about the mailbox rule in this essay? 100%. But let's just, we're ahead of the class. This is why this is a live interactive class. We learn every day. So, I would have missed that 100%. I could pass the Florida bar exam tomorrow. I promise you that. I also would miss a lot of things. It's a very, very hard test. We're not going to get 100%. I'm human, but we're learning together. So offer, acceptance, consideration, mailbox rule. We define what the mailbox rule is, but now we know the mailbox rule under the majority rule doesn't apply to options contract. But he still talked about main things. We talked about the firm offer, 90 days, and it's going to be held for 1 year. Here, he just goes into analysis. It's a valid contract. It's a requirement contract. It's okay. We should have mentioned this. I was thinking about that. The difference between a output and a requirement contract, right? He even says it right here. Another type of contract is an output contract. Cool. I love this guy. Remember, these are the model answers. We love these people. Or girl, most likely girl, to be statistically fair. To offer an acceptance, create a valid contract. The type of contract created was a requirements contract. Let's tease this out. A requirements contract is a contract where the seller agrees to supply all that the buyer requires. A requirements contract is valid under the Ucc, even though the quantity terms are not specific. Another type of contract, and this dude was just getting brownie points right here. Another type of contract is an output contract, which is a contract where the buyer agrees to buy all that the seller produces. However, in this fact situation, output contract was not created. I love this model answer because this is a guy just proving my thesis, just to say stuff to get more points. Like this does not even apply, but he just states it. But I love, this is the process that I want you all to replicate on your own. Going through essays, issue spotting. I'm going to require at least one full-length essay per week. It's going to move up to 2 and then 3 before the test. But for now, one essay that you're going to write in full. But on top of that, just looking at essays, issue spotting, and then reading the model answer and filling in the blanks a little bit. We did a great job. We collectively would have gotten a passing score, but we did fill in some blanks. The blank we filled in was that the mailbox rule is not going to apply to an options contract. And another blank we just filled in is this requirements contract. We got to talk about what a requirements contract is and how should we have known it's a requirement contract. I saw that. Any jet fuel ordered by you. We kind of skipped over that. Not next time. Any jet fuel ordered by you is a requirements contract. It would be an output contract if they said all the jet fuel you produce. Let's learn that. I'm like, we're learning together. We're sharpening our irons together. A requirements contract is anything that you produce or anything that
You need.
that you need. Thank you. Anything you need is requirements, whereas output is that anything you produce. All right. They're going to go a little bit deeper into requirements contracts here, it seems. A valid contract under the Ucc was created. It's a requirement contract in the upcoming year. They ordered this for that. They could argue as a breach of contract on the terms because it was set at this. This would likely not be a breach given the circumstances needed to rush shipment. They relied, so we talk about their reliance, on the contracted price of $150 for 2007. Since this was a requirement contract, they were reasonable in canceling all negotiations with other suppliers for fuel. We definitely want to identify that, the reliance on that. Breach of contract. Airline. Oh, Lewis is back in. Breach of contract. Airline may have a breach of contract claim against Oil for revoking the contract. Oil's attempt to revoke this offer is likely a breach since Oil's offer to supply airline with the fuel was accepted orally by airline. An offer can only be revoked before acceptance. Someone definitely mentioned that. Here, airline would argue that the Oil breached the contract to supply jet fuel when airline received a letter from them. Revocation of an offer is effective upon received. We said that too. Airline would claim that he entered into a requirements contract with Oil and he breached the contract by failing to supply. You see how they're getting just like arguing back and forth with themselves? That's fine. They're getting their points with the issue spotting and the definitions, right? An offer can only be revoked before acceptance. That's where you get a major point for, right? You know, revocation of an offer is effective when received. Like that's where you get the points for right here. A requirements contract is a contract where the seller, you know what I'm saying? That's what I want you all to tease out and make sure that you're dropping in your essays. The argument back and forth is just to keep the reader interesting. Who knows what the correct answer is most of the time? We're going to argue both sides. Even if the transaction was a separate contract, now you're just getting hypothetical. Arguably, the letter sent to Oil silence would silence imply a contract under exception under the Ucc. I don't know what they're talking about here. Okay, defenses. Definitely, we talked about statute of frauds. That was a big one. Firm offer, we talked about too. Firm offer is not revocable under UCC. UCC permits a firm offer for 90 days. In this case, they're obligated to keep it open for a year. We talked about that. If 1 year provision of the contract is not enforceable because of offensive statute of frauds, then 90 days ends March 15th, right? That's a good point. If they're saying that because the statute of frauds would invalidate the other contract, the options contract had to stay open for 90 days. Promissory estoppel, we didn't really mention this. It's a hard thing to identify, so let's kind of see how they identified it. Promissory estoppel is the equitable doctrine for enforcing a contract when one party relies to the detriment of the promisor or another. We saw detrimental reliance. We should have triggered that in our minds. Detrimental reliance, promissory estoppel. Even if there's not a valid requirements contract entered into, they relied on the promise. Key to promissory estoppel is reliance. The reliance would be promissory estoppel. Statute of frauds, big one. They're going to argue statute of frauds. Under this exception, it provides that a contract is enforceable even if the contract is not signed. It allows a letter signed by the plaintiff to be sufficient. There was a history of dealing between the party. A defense of statute of frauds they substantially performed. So I don't think they did a good job writing about this, but they identified statute of frauds. They identified the substantial performance. And then they talked about the claims of the oil company. Basically, they started calculating what they would have the sale for. They would likely have a claim for the price of the fuel shipped in December. They would argue that the airline offered to purchase 100,000 barrels from oil over the phone and that oil accepted the shipment of barrels of that day. Acceptance by good is a valid form of acceptance. They would argue that they're entitled. So they're just saying that they're entitled to enforce the contract. A valid contract was in existence and they're entitled to enforce it. Anything else? A series of contracts were entered, not a requirements contract. So they're kind of arguing against themselves, whether there was multiple contracts, which is what we kind of said, or whether there was a requirements contract. Mailbox rule, they said it doesn't apply. They're kind of going in the same thing. Finally, impossibility of performance, they would argue that there's severe change that they did not contemplate that materially affects performance. An act of God is one change. And then the statute of frauds, talked about again. And finally, they end up with anticipatory repudiation. They would argue that they were going to repudiate. This was a really tough essay, I think, because it was so narrow. But I just wanted to, we're going to do multiple essays. We did good, though. We identified all the main points. And you see, it really starts with a strong foundation of just identifying what is a contract, what's going to be involved, and then just getting the key definitions. Then you just kind of argue both sides. Let's look at another one and see how it could, what else we'll encounter. Another good essay. Let's see another good year. 2016, yeah, that's the year I graduated. Got my JD MBA. I would have graduated in 2015, but I wanted to learn about business. Okay. Who wants to read the first paragraph? Let me just read the call of the question. Her rights and responsibilities with regard to the university, Bill's company, and the patent. So remember the patent. Write a memo analyzing the likely claims, defenses, and outcomes for each party. All right, who wants to read the first paragraph?
I can do it.
Good.
Professor is a surgeon and expert on artificial limbs. A private university in Florida offers professor a job at its medical school, and she agrees. The university issues a press release stating professor will teach surgical procedures for artificial limbs and conduct research in that area, with the university owning any patents she develops during this time. Professor will be paid $250,000 a year for 5 years and cannot be terminated except for cause upon 90 days notice. Professor signs a copy of the press release and delivers it to the university president's office on her first day.
Okay. What do we have here?
An employment contract.
Employment contract. Remember the concept of being at will, right? Unless it says otherwise. She's going to teach surgical procedures, and they're going to own any patents. She'll be paid a year for 5 years and cannot be terminated except for cause upon 90 days notice. She signs a copy of the press release and delivers to the university on her first day. So seems like we have offer, acceptance, consideration, right? We have a valid contract. We're going to get all those points for contracts. Okay, 3 months later, Bill, local businessman who knows that the professor did her early work in DNA research, writes a letter to professor offering to produce and sell DNA test kits developed by professor in her spare time. Attached to the letter is a licensing agreement giving Bill exclusive rights to professors' future patents for DNA kits. The licensing agreement also provides Bill will pay professor $5,000 for each idea that's produced, and professor will receive 25% interest in the company if any item is produced for the next 5 years. Also attached to the letter is a schedule of infomercials for professor to tape and a form stating that professor will not work in a similar field for 10 years after the sale of her interest in the company. I'm looking at this backwards, but what's the last thing really show to us?
A non-compete.
Definitely non-compete. And what do we know about non-competes, Joel?
That they will be generally not enforced.
I don't like that.
Generally enforced them as long as they're reasonable.
Sorry, yeah. If they're reasonable within the duration and scope, they'll be enforceable.
Yeah, let's just kind of there's no generalization when it comes to non-competes. In a practical sense, most employment contracts do have non-compete agreements. We need non-competes, and they are enforceable, but they need to comply with pretty strict parameters. They need to be reasonable in duration, like how long. Like you can't tell me, like, think about it a lot like a radio host. That's what I remember we did in law school. There was like this one radio host, and they had a non-compete where he couldn't go to another DJ station for a certain amount of time. Like that is kind of fair. You don't want just like DJ from Miami radio to go to Miami X radio from Miami Y radio and kind of take all their stuff and take all their fame and just, got to give it some time. How much time? 6 months. Now, can this DJ radio from Miami go up to Georgia and do it a week later? Probably, because you're not in the same market. So it's got to be like time. It's got to be reasonable. We said 6 months. Under 6 months is presumed reasonable in Florida. Over 3 years is presumed unreasonable. And then it kind of had like a 2-year piece in there as well. So it's got to be reasonable in time. It's got to be reasonable in geographic scope, meaning how far, Broward County, West Palm Beach. And then it's got to be reasonable in subject matter. Like, you can't have, I'm a DJ, and now you're saying that I can't even do public speaking engagements. Like that has nothing to really do with being a DJ on the radio. It's got to be very narrow. We're not trying to prevent people from making a living. We're really trying to protect the business from not having our trade secrets and stuff. Like I do have a non-compete. I don't want someone just to go to, Victory Tutoring and just teach them all how I do things. Like you got to let it shake out a little bit. So, okay, we have the non-compete here with those 3 particularities. Anything else here?
Well, that's a new offer, right?
New offer for sure. Definitely.
Do we have to like mention it and not define it all over again, right?
Don't repeat rules that have already been repeated. Say, here we have a subsequent offer for a contract. A contract must conform with the rules stated above. Don't restate the rules. You're not going to get points for restating a rule that you already stated, but you will get points for doing the analysis. Like here, this constitutes an offer or invitation to deal. What is it? Is it an offer or an invitation to deal? Offer to produce and sell in your spare time. There's a conflict of interest going on right here, right? When they says that owning any patent she develops during this time, and they're trying to get her to develop patents. Okay. She mails the entire package back to Bill. At the bottom letter, she writes, "We'll see how it goes," and signs her name. On the licensing agreement, she changes the fee from $5,000 to $75,000. What do you think about this paragraph?
I would say that you can argue that that's not a valid acceptance because it's not a, it doesn't clearly indicate assent to the terms.
Right.
And then also you have additional terms in the acceptance.
Counter
It'll be a counter. Yes, it's a counter.
Right.
super counter offer. Make sure we know again all the points right here about UCC, common law, mirror image. You'll see with contracts that you just gotta get that main start, and then it gets in the weeds a little bit, and you just start arguing both sides. But you gotta have a strong foundation. That's why I really focus on it. All right. Within the first year, professor develops and patents a home test kit to identify cancer genes. Bill starts production and sends her a $5,000 check. Professor calls Bill and tells him he owes her $70,000. Sends a second check. So he sends the check for $5,000, then sends it for $10,000, and Professor cashes both checks. Professor never takes any info commercials. She uses a controversial advertising campaign that targets the fear of cancer, and the company makes millions of dollars. Okay. Interesting stuff right here. So she starts production and sends, so she's sending her money and he cashes the check. It's definitely some partial performance, right? Was there statute of fraud issues anywhere involved here?
Isn't it because it's for the next 5 years?
Yeah, exactly. Good catch. I knew it had to be somewhere. There's always statute of frauds. I'm not gonna lie. You have to overcome statute of frauds.
Yeah, 5 years can't be completed in a year.
Perfect. Must conform to statute of frauds. Boom. It's a letter. See how it goes. But it could be by performance, reliance, cashing the check. A lot of different things here. After the first year, fires her without notice. Breach, right? Because it says.
Which cause?
So we're definitely going to talk about that. Termination letter refers to the marketing controversy, but also claims ownership of the patent for the DNA kit. Okay.
So she got the cause, but didn't get the 90 days notice.
Didn't get a 90-day notice, exactly. Professor finds a buyer for 25% company, but Bill denies that she has any ownership interest. Without income from the university or the company, accepts a job with a different company to produce DNA test kits for pets. Bill threatens to sue if she works at a company. For pets, that's going to be subject matter, right? In terms of non-compete. What else do we think of right here? I'm just kind of, we're running out of time. We're kind of thinking quickly, but what about accepting a job with a different company after being fired? What does that bring up in your mind?
The non-compete agreement.
And what else in terms of damages?
Mitigating damages.
Mitigating. Makes me think of that. Let's just kind of scroll through the answer and see what we got, and then I'm going to assign you all homework, and we'll call it a first weekend, unless you're joining me at Fairfax. Okay. First issue is whether to enter a valid contract. Please, if we learned anything today, it's that this is how all of them start. I'm going to teach you that there's a basic outline for like every single subject. Some subjects then branch off. Some like trust, secure transactions, those are the top two I can think of, are literally just one essay. It's like if you just memorize one essay, you're good. Some of them, like con law and real property, branch out in a lot of different directions. There's not just one outline. There's a lot of different ways they could test it. Then most of them are like contracts, where there's like a really strong trunk foundation, and it's the same. And you gotta have that trunk foundation memorized, and then it could branch off a few different ways. But if I can teach you all anything about how to write these essays, it's be very good at writing the foundation and getting the points that you're going to see over and over and over. So here, valid contract, offer, acceptance, consideration, 1 year, statute of frauds. We talked about that, the seal. Okay. It does not appear to be in writing, but then they say in writing. They just go through a whole lot of things, whatever. Substantial performance, that they were fired without notice. They will argue they're not bound because there's no writing. They'll argue that either there's no writing, substantially performed, promissory estoppel. We kind of talked about that, or not really, but we have talked about it a lot today. Unjust enrichment. They're just arguing both ways, that if there was a writing, they'll argue this. If there's not, they'll argue that. They do a good job. They can argue that the agreement was ambiguous. Ambiguity, that's a good argument. We didn't really talk about that. That's good for them. Ambiguous. I mean, probably isn't ambiguous, but they're saying as to what is meant by just cause and what type of patents. Yeah, fair enough. I like that. It's ambiguous. Good job for this student. And we should, be more keen on that. The terms of the contract, there was some ambiguity about what is meant by just cause and what type of patents. Really trying to put our lawyer hats on here. Boom, patents are 5 years or less. We only know that because I mentioned it before class when we talked about it, but don't be crazy if you didn't know that. It's very rare that that'll be tested, but the more little things you can know. In our world, it's 6 months in Florida, under 6 months is deemed reasonable, over 3 presumptions. These are all presumptions. Presumed reasonable under 6 months, presumed unreasonable over 3 years, and then they're usually up to 2 years. Parole evidence they talked about, any contemporaneous evidence. They just said in the event they didn't really talk about it, they just kind of add that definition in here, but we understand that. The no notice, due process, they're getting out of pocket here. Okay, contract formation bill. See what they said right here? See above regarding contract formation issues. We're not going to get any points for rewriting all the rules. It may be accepted by any reasonable manner, implication. So you see there's 2 different contracts here. We're going through both contracts. UCC, sale of goods over 500. Therefore, it's going to be Statute of Frauds. We could have talked about predominant purpose because there's different things to do. Common law, mirror image rule. We already know about that. Additional term. And then they added about accord and satisfaction. I don't really know where we saw that, but contract modification requires consideration. So we talked about that. There's going to be a modification about how much money was going to be. The non-compete. This is getting really great. This is a really good answer. Blue penciled by the court. Blue pencil is reformed to conform with reasonable time limits. That's a court. That's a equitable relief. It's unenforceable as written, the non-compete agreement. Because when we saw the non-compete agreement at the top, where does it say the non-compete?
I think it was in paragraph 2.
So, yeah, it's the bottom of paragraph 2. Also attached to the letter is a schedule.
Oh yeah, the last one.
Yeah, if one marshals professor to tape and a form stating the professor will not work in similar field.
Right. Again, we were flying through this because we're 3 minutes over the time limit of class, but 10 years, that's ridiculous. We're not going to do 10 years. So, they did a really good job of being la, 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 they could blue pencil it and change it, but truthfully, it's not okay. But you see how this is model answers. Strive for the model answers, but no, these are model answers. They will not be successful in claiming ownership because the non-compete. Okay, that's fine, fair enough. So this was a good start. I mean, we're going to leave no stone unturned. Now, the way that this course is designed is we meet on weekends, which gives you a lot of flexibility during the week for what you're going to do. I have very simple assignments. This week, I need you to master contracts. I need everyone to pretend like Saturday they're being tested on contracts. And the way to do that, 25 MBE questions per day. So you should get through 125, maybe take a day off, get through 100, but at least 100 MBE questions on contracts. Now, on top of that, I think everyone should go through this drive, right? And read every single essay, issue spot it, and model answer and read it. These are my recommendations. Do 25 MBE questions per day. Those are doing MBE. Now, for the student here who's not doing MBE, super lucky for you, just do what I'm talking about for Florida, which is read every single one of these and the model answers. And then I need everyone to pick one of them that they're not going to read the model answer and they're going to write the answer to under time circumstances, meaning you have exactly 1 hour to write that essay. And I want you to submit it to us. Send it to me, Alexis, or Simran. Simran will probably set up a folder for you. That's definitely what she'll do. And then you could add it to that folder and we'll, be able to see your improvement. But like, if you only do one thing this week, that's what I need you to do. Write me one essay, timed, don't cheat. I want to see where y'all are at, and that way we can individually work with you. You're all at different levels right here. Be fair with yourself. So one timed essay, 1 hour time. I recommend 25 MBE questions per night. If you miss a day because something bad happens, you don't have to do 50 the next day. Just get back on the schedule. Try to be regimented. Try to create a healthy regimentation. If you want to just knock out 25 questions today, come to my class at 4 o'clock. That's exactly what we're going to do with 25 contract questions. And then read all these essays. Just boom. Open it, read it, try to outline it. Try to, don't worry about the other piece of it. Just try to do the contracts part, but try to identify the issues, then read the model answer, and just take note about especially what's the definitive language they used. Try to memorize that language. I want you to be masters of memorization. And what issues did you miss? What did you, miss? And you won't miss it the next time. What did we miss today? I'd say the big one is a requirements contract. We weren't keen on recognizing the requirements contract. And then he also talked about the output contract. Anything else? Oh, the mailbox rule, how it doesn't actually apply to option contracts under the UCC. Look, no one knows that. Your professor in law school doesn't know that. He would have to look it up in his book too. Don't get down on yourself that you don't know the tiniest crevices of the law, but strive to learn them, because we are competing here against other students who are trying to learn stuff. And, they're mostly starting on Monday. Monday, meaning tomorrow, is when the commercial courses are going to start. So we have a head start. I think so far, this has been a good weekend of doing contracts. The thing that I will definitely say about this, don't you dare think I have plenty of time. I'm going to learn this slowly. Like, we're not usually going to have a whole weekend to do a single subject. Do the math in your head. Usually we're going to do 2, maybe even 3 subjects in a single weekend. This was just like a nice, introduction. It's going to get real heavy real quick. And, for me, I love when it's about to be bar prep, when the test is about to be administered, because everyone's freaking out. They ran out of time. They need to do one-on-one tutoring sessions. And, it's great for business for me. But I'm trying to help you all and let you know that, you have to have that, recognition and urgency. There has to be an urgency now that time is going to come quickly. There's going to be some sort of event or catastrophe that's going to knock off a few days from your schedule. And I'm not going to really talk to you ever again about contracts. Probably that's a lot. I do a lot of drill sergeant. I will force you guys to offer acceptance, consideration, no valid defense. That'll come out, and we're going to keep building upon it. And contracts is so foundational that I don't mind that. But we're never going to have a full lecture on contracts again. Maybe a tiny, tiny little bit, but just know that it's going to move really fast. Let's make sure that we're accomplishing what we're doing, which is one subject at a time. And then we'll continue to revisit those subjects and make sure that by test day, we're confident in every single subject. This week is all about contracts. 25 MBE questions a night. Read over all those essays and the model answers, and then pick one of them to do blind, 1 hour, and submit it to us. And then, that's your assignments. Anyone have any questions about that at all?
So wait, repeat that last part again. Sorry, you were cutting out.
Okay. 25 MBE questions on contracts. We're only.
Oh yeah, I heard that part. You just cut out on my computer when you were talking about the submission.
The what?
Essay submission.
Oh yeah. If you do it, Simran's gonna reach out and probably have a Google Drive folder set up for you. If you do it before then, just email it to me, Andrew@ibisprep.com. I'm really gonna take the time with each one of you to read over your essays and see where you're at. If you want to do more,
just any essay from the contracts, like any contracts essay from the bar website.
Yeah, that's fair enough. Just let me know what year it is. Don't look at the model answer, and that's fair. And yeah, that's a good start. Just for now, we're gonna do one essay for now. In coming weeks, we'll do more. But don't fall behind. I really want everyone to get a good start and take 1 hour to write this essay. If you run out of time, press enter. I just want to see where you're at. But you guys feel good about contracts? I'm going to stop the recording before we get the negative energy. Now, thank you all so much for the first weekend. I think we had a good start. I'm going to stop the recording.